RS11 from the series called the Courtroom Voices from AAA Insolvency. I am Anil Goel from AAA. Today we are discussing a judgment which is on the basis on Employees Provident Fund and gratuity. The basic issue in this is whether the resolution plan can be approved without even providing for Employee Provident Fund and the gratuity. It is in the case of Blarpur Industries Limited. The application was filed by Shri Gopal Paper Mills Labour Union and Shri Gopal Paper Mill Kamgar Union. They were all the labour unions of the corporate debtor. Respondent is in this case is Anuj Jain, who is the RP in this case, and other respondents are the FinQuest Financial Services Private Limited, who are the successful resolution applicant, and the proposal is pending before the NCLT. So this is the case which is there in NCLT. Now the resolution plan, the issue was whether the resolution plan must include the full payment of Provident Fund and gratuity dues. This judgment was delivered on 1st July 2024 from National Company Law Appellate Tribunal, Principal Bench, New Delhi. Now in this case, what we have seen is the Anuj Jain, the resolution professional, the Committee of Creditors, and even the FinQuest Financial Services, they were all arguing. And when we see the facts, the facts are very clear. The fact says that the CIRP started in January 2020 and the resolution professional was appointed to manage the insolvency process. The management of the corporate debtor filed a claim on behalf of the workmen for about 40 crore, which was admitted by the RP at 6.61 crores for 24 months and some small amount for 12 months. The CIRP commencement date was important, 24 and 12 months. Now the resolution plan was admitted and it was submitted by the FinQuest Financial Services. The clarificatory note was issued on 22nd of March 2022 and the plan was approved. What was the clarificatory note regarding the Provident Fund and the gratuity? Now the IA was filed with this workmen union. They were arguing that the resolution plan does not provide for payment of Provident Fund and gratuity. They claimed that the entitlement to full Provident Fund and gratuity until the insolvency commencement date. They also referred to the judgment in the case of Jet Airways Maintenance Engineers Welfare Association versus Ashish Chaucharia. It was held that workers are entitled to full payment of Provident Fund and gratuity in that case. Now the total outstanding towards Provident Fund and gratuity was about 11.49 crores and 8.84 crores. So total in fact was about 20 crores. Now the respondents were saying, like resolution professional and Committee of Creditors, they acknowledged the Provident Fund and gratuity liability. But they were saying that the claim was not filed correctly by the workman. They also maintained that the commercial wisdom of the Committee of Creditors cannot be questioned because there are many judgments. Now the resolution professional in fact admitted the total Provident Fund dues of about 11.49 and the gratuity dues of about 8.84 crores. Now the legal issue before ANCLAT was whether the resolution plan must include the full payment of PF and gratuity. The interpretation of section 30 subsection 2 was also read, and the judgment in fact which was earlier passed, the judgments in fact which was earlier passed in various other cases, that was also referred. The Jet Airways case was the most important, Jet Airways Maintenance Engineers Welfare Association versus Ashish Chaucharia. Then that was followed by the Silpi Constructions Contractors versus Union of India. Then there was another judgment which is the Autumn Investment and Infrastructure Limited versus Sarai Equipment Finance Limited. So these are all the judgments. So hardly there is any conflicting judgment. So the primary decision was based on the Jet Airways. Now the court said that I cannot reject the resolution plan. So the court approved the resolution plan but declared that the workmen and employees are entitled to full payment of provident fund and gratuity. The amount of provident fund and the gratuity dues computed that has to be paid in priority, and therefore this resolution plan was approved. This is for Bularpur Industries, and the payment for provident fund and gratuity was assured. Now this judgment also reinforced that the workers are entitled to their gratuity full and also to their provident fund, and even if it is not provided in the resolution plan, even if their claims are not filed, the resolution plan must provide for it. In case it is not provided, then the court will ask you to provide for it. Thank you very much.